Watchers, before we begin, I want to make this absolutely clear. The following broadcast contains public domain courtroom footage, commentary, and legal analysis. This content is presented under the Fair Use Doctrine as defined by 17 USC 107 and is protected by multiple Supreme Court rulings, which you see below. This stream is transformative, educational, and journalistic in nature. It includes original commentary, trial breakdowns, legal interpretation, and critical analysis, not raw redistribution. We do not claim ownership over any public domain footage, and all use is strictly within legal bounds. If you're watching this content, you're engaging in a protected, transformative experience, grounded in law, never in speculation. And if anyone has a problem with that, take it up with Campbell, Brady, Miranda, and Irvin. Remember, guys, justice always works better when we watch. So keep watching. See you in the courtroom.
Testing 1, 2. Yeah, and then you should hear what it says in a second. Sweet. All right, thank you. All right, thank you.
The Honorable Judge Murphy presiding. Good morning, Your Honor.
Good morning. Good morning. Good morning, everyone. Thank you. You may be seated. We are here today for the matter of State of Connecticut versus Jose Morales. I would like to ask counsel please to first place your appearances on the record.
Howard Stein, Supervisory Assistant State's Attorney for the State, Your Honor.
Mark Durso for the State of Connecticut, Your Honor.
Good morning, Your Honor. Edward Gavin for Mr. Morales, and seated to my left is my assistant panel, Peter Messer.
All right, please. Please bring up Mr. Morales. Thank you. Good morning, Mr. Morales. Mr. Morales is present in the courtroom. All right, counsel, first I'd like to thank you for your patience this morning. I know that we did meet and we did review some requested changes relative to the pre-sentence investigative report, which I'll get to those changes in just a moment. We did make that request to probation, and I did just get back the amended report from probation. So I apologize for the delay, but I do have a copy of the amended report. My understanding is that probation was forwarding a copy via email to both the state and the defense, but we will go through the changes and confirm that those changes were made in the report prior to its filing with the clerk's office. Okay, thank you so much. All right, so the first matter that the court is going to take up, because I know that the matter has been scheduled for sentencing, is there were two motions that were filed in connection with this case post-verdict. That was a post-verdict motion for judgment of acquittal dated May 5th, 2025, as well as a motion for a new trial, also dated May 5th, 2025. Those were filed on behalf of the defense by Attorney Gavin. At this point in time, I would go ahead and conduct the hearing on those motions before moving forward. So, Attorney Gavin, is there anything in addition to what is contained in your written motion that you'd like to put on the record?
No, thank you, Your Honor. Just for the record, in regards to the motion for a new trial, I'll stand by the pleadings that were filed as well. And then, Your Honor, in regard to the post-verdict motion for judgment of acquittal, I would also stand by the written pleadings. I don't have anything else to add at this juncture regarding either one of those motions.
Thank you. Does the state wish to be heard?
I would just simply respond by saying I would ask the court to deny both of those motions, that there is no basis in fact or lawfully granting a refund.
All right, very good. So the court has had an opportunity to review both motions prior to coming on the bench today, as they were previously filed with the clerk's office. Upon hearing no additional evidence or argument, the court is going to go ahead and deny both the post-verdict motion for judgment of acquittal as well as the motion for new trial. The court will submit a memorandum articulating its decision on both motions in due course. Thank you. Moving forward to the sentencing proceeding, the defendant stands before the court today having been found guilty after a jury trial of murder in violation of Connecticut General Statutes Section 53A, 54A, and tampering with physical evidence in violation of Connecticut General Statutes 53A-155, that verdict having been recorded and accepted by the court. A pre-sentence investigative report was requested pursuant to statute. It was received and reviewed by the court. The court did become aware that in accordance with our statutes, counsel on behalf of the defense as well as the state have received a copy of that report. So I'm going to start with the defense first. Attorney Gavin, have you had a chance to review that PSI report?
Yes, Your Honor, yes. I've had an opportunity to review it.
Yes.
I have formally lodged my objections with the Office of Adult Probation. And for the record, I just indicate that Peter and I went to Cheshire, sat down with Mr. Morales, went through every page of the extensive report. The objections that I had were reviewed with him at that time, and he was conversant with the report.
All right, very good. So, Mr. Morales, I am going to just ask you directly, sir, you've had an opportunity to review the pre-sentence investigative report with your attorney?
I did.
All right. And Attorney Gavin, the objections or the request for amendment, if you could just itemize those for me at this time. I think I have an understanding, but.
Certainly. Thank you, Your Honor. Pursuant to my interaction with the probation department, there are a number of comments that I had. Your Honor, the first was on page 3 of the report under the current offense section. It reads incorrectly, on April 22nd, Morales pled guilty, and that should read found guilty after trial.
All right. So the court did receive notice in advance of that requested modification. I did provide authorization. The state was made aware of it as well and did not object. Was that correct, Attorney Stein?
That's correct, Your Honor.
All right. So that change has been made in the court's amended PSI report that the court has here on the bench. So I will let you know that, and I will go ahead and order that change on the record.
Thank you, Your Honor. Thank you. Your Honor, on page 5, and if I may just address this issue at the onset, I had advised the probation department, and we had some discussion this morning, that it is my position that under Connecticut General Statute 1-1K, as well as the definition of family members under Connecticut General Statute 1-79, the individuals that should be permitted to go ahead and testify in court should be limited to the brother and the mother and anybody else, the brother's girlfriend, corollary aunts. I'm not sure of the relationship between everybody because obviously their names were not disclosed in the probation department's initial pleading. I had been able to include that the person regarding immediate family members has been found to be a spouse, a child, a dependent relative, and under the law, my position is that that should be strictly construed, and so therefore I would ask the court to go ahead and limit who is permitted to go ahead and address the court, and I recognize that the court has discretion. I do. The other thing, if I may just address at this point, just to get out of the way, this is a case involving Christine Holloway, and I would object to any information, discussions, pleadings involving Vanessa Morales. That is not part and parcel of the case, nor was there a charge in that report.
Thank you. Attorney Gavin, was that it for requested changes?
On that section, yes.
We can move on to additional ones, and then I'll
Okay.
take up the issue of the victim.
Thank you, Your Honor. On page 8 of the original pre-sentence report, there was a notation from one of the individuals that had submitted that it was addressed to Judge Strackbein, and Your Honor's done a great job here, and it should be Judge Murphy. So that was a minor typo.
All right, so we'll make sure that Judge Strackbein is into this trial, but the court's suggestion at that point in time, upon discussing it with counsel and reviewing the requested change, was to just either use the substance of the victim statement in the PSI or put in parens Judge Murphy next to Judge Strackbein. The victim's advocate did indicate to all of us that, in fact, the letter was written to Judge Strackbein. So in keeping with the authenticity of the author, the court didn't have a problem with leaving Judge Strackbein's name, but for purposes of clarification of the record, felt that my name in parens should be next to Judge Strackbein. So I will just let you know that in the amended PSI, it does appear that there has been an insertion at my request, parens, Judge Murphy, close parens.
That works fine for us. Thank you. Your Honor, just going forward, on page 19 of the original pre-sentence report, in regard to family background, there was a reference to Mr. Morales, my client, and it should read Mr. Garcias, who's present in the courtroom. So that was just in a typo in regard to the last name.
Right. And Attorney Stein, just for clarification on the record, you had no objection to that particular amended part of the PSI. So the court did look at that. It did appear to be a typographical error, and I did request that change as well, or authorize that change, and it has been made in the amended report that I'm looking at.
Thank you. And my final comment, Your Honor, on page 24, which is similar to the first objection, under summary and recommendations, line 1, it says having pled guilty, and that should obviously be having been found guilty. There was no plea in this case.
And again, Attorney Stein, there was no objection to that change.
No, Your Honor.
All right, very good. So that had also been requested, and that is one of the changes that was made. I do see here in the newly filed PSI provided to the court.
Thank you.
I have a copy of sitting in your email, but I didn't want to delay any longer, so.
Thank you very much. Your Honor, just finishing on the PSR, I just want to make sure I had submitted to the probation department. My client had completed any number of courses while he's been incarcerated for the last 5 years, and I asked them to forward those to Your Honor. I have courtesy copies for Your Honor if you like them.
I don't have those courses, so why don't you please provide them, or assuming the state has no objection to those coming into the file. Thank you. Thank you. I'll have those marked as a court exhibit. Thank you. Anything further relative to the pre-sentence investigation?
No, thank you. Thank you, Your Honor.
Morales, were there any additional requests or changes or things that needed corrections in the report that you had wanted that weren't addressed by counsel?
No, Your Honor.
So at this time, I will hear from the state. Attorney Stein, you have a copy of the original pre-sentence investigative report too. Could you please let me know what changes, if any, you had requested?
Yes, Your Honor. So first of all, I'll simply point out that by email dated June 26, 2025 to probation, which was CC to Your Honor as well as to Attorney Gavin and the victim's advocate, I outlined at the time various provisions where I was flagging for the court and probation and for Attorney Gavin things that I believed required the court's attention. On page 1, I did note under alias or nickname, there was a reference to police set bond. I received an email back saying they put that in there because in whatever official court or legal documents that apparently appears there. So I will obviously defer to the court on that.
Let's take one at a time. Attorney Gavin, you had no objection.
No objection. Thank you.
Go ahead and request with the no objection due to our prior meeting and the emails that were forwarded concerning the changes to the probation officer. I did request that it be deleted. And again, in the most recently received report, which I just received a few moments ago, it has been taken out. So that has been deleted.
I did note in on page 2, Your Honor, under current offense, and I've been doing this a long time, and perhaps it just has gotten by me to this point in time, but when I was reading the factual basis, the current offense section, it became apparent to me that the name Christine Holloway was not mentioned anywhere in that factual section, and it sort of it dawned on me, or there was sort of a profound thought that this is a document that is being prepared for a person who has been convicted of a homicide crime as it relates to her. This is a document that is going to follow Mr. Morales through his entire remaining time in the criminal justice system, which includes the Department of Corrections, presumably, as well as then eventually parole boards or sentence review courts or appellate courts. And nowhere in the document that is here defining this offense does it even mention that it relates to the death of Christine Holloway. So I had offered a suggestion to the author of the PSI on page 2 that in this sentence, a welfare check was requested for the victim. I suggested a comma and then adding the victim's name, Christine Holloway, comma, an employee, and then having it continue. So at least this document will forever be associated with the death of Christine Holloway, rather than just being completely devoid of that information.
All right, Attorney Gavin, did you have any objections?
I have no position on that.
Thank you. I just want to state for purposes For the record, Attorney Stein, I appreciate your comments and your request, and in fact, that request was authorized by the court, and that has been made as an amendment to the most recent PSI report. So the second line will read, welfare check was requested for the victim, comma, Christine Holloway, comma. And I just want to put on the record that the underlying facts of this particular charge of murder do qualify as a domestic violence crime. I think that's why the probation officer in drafting this report did not disclose the name of the decedent and maintained the anonymity of the decedent. However, it's my understanding, as well as also referring to victim's sister and other relationship identifiers throughout the report instead of the victim's sister or other witnesses' names in protecting the anonymity of the decedent. However, it is my understanding, Attorney Stein, that you have checked with family representative and family members, and everyone is in agreement with placing Christine Holloway's name in the document and did not have any objection to having their own names placed as witnesses who wished to give a victim impact statement as well. Is that correct?
So that is correct, Your Honor. And I will further add that reading through the written statements prepared by people affected by this matter, it was difficult reading through with the edits and deletions that were made in an attempt to maintain privacy for victims in general, or specifically with regard to domestic violence type cases. I found it difficult, and I am familiar with many of these people, sort of identifying. I have spoken with them. I've spoken with the victim's advocate, both in past periods of time and as recently as moments ago. They all desire their names and levels of relationship to Christine Holloway to be printed both in the PSI, and they have no objection, obviously, to their names or likenesses being part of this record for any of the media that is covering this matter.
So, Attorney Stein, I am looking at a revised report, and I do have some names in it as requested, but I will go ahead and order on the record that all names of any of the victims' relatives who provided a statement should be identified.
And level of relationship, please. Thank you.
Relationship as well.
Thank you.
Are there any additional changes?
I did also point out, and I will defer again to Attorney Gavin on this, on page 2, section, same section that I was previously referring to. Fourth paragraph from the bottom, Mr. Morales was arrested for firearms possession. Mr. Morales is, with regard to the matter which is pending here still, which is docket number AANCR 19-022552T, which I will take action on at the end of this matter today. Mr. Morales was not arrested for firearms possession charges. He was arrested for electronic defense weapon possession. And I offer that up just as a clarification to avoid the appearance of any type of prejudicial or incorrect information in the PSI.
Yes, and thank you. Attorney Stein did alert me of that, but I understand that the state is not pursuing prosecution on that matter, so it's sort of a moot issue. Thank you.
So it had been addressed previously to coming on the record today. It had been provided to the probation officer who authored the report, and the change has been made. So it does currently read correctly, Morales was arrested for electronic defense weapons possession.
Other than that, I also had flagged for probation in court as well the incorrect statement in 2 places with regard to this being a jury verdict rather than a plea of guilty.
Yes, and that has been fixed as well. All right. So then, Attorney Stein, I'll hear from you now, if you don't mind, on the defendant's position relative to the victim impact statement. But I want to say, now that I have an amended report, it's Jody Jacobellis.
Yes, Your Honor. So with regard to the statement, the written statement submitted by Ms. Jacobellis, and ultimately what I expect will be her comments to the court, when I received Attorney Gavin's objections to that, my first thought went to Ms. Jacobellis and realized that if there is anybody that is more intimately connected with the entirety of this case, I can't think of who that might be. She was one of the initial people that were contacted when Christine Holloway disappeared and was unaccounted for. She is the longtime girlfriend, I understand, fiance of Stephen Holloway, who was the Christine Holloway's brother. Stephen and Holloway and Jody Jacobellis together single-handedly led the charge to continue to investigate the disappearance of Christine Holloway, enlisting the help of the Ansonia Police Department in time, and continuing to push the Ansonia Police Department with regard to the passage of time and the results of their own investigatory efforts that they undertook to try to locate Christine between an initial complaint that they made and then a subsequent complaint later on in the evening. It seems that I have been doing this a long time. I have often heard from many people on both sides, both for victims presented by the state and others presented by the defense, who have some personal connection either to the defendant or to the case in general, that are often heard from. I believe it is in the court's discretion to allow people who have had a direct impact by crime. And quite frankly, I think in Connecticut more than any other place, perhaps, we do not stand on labels of what traditional families are or intrude into levels of relationships here in the state of Connecticut to define families or to define relationships. And I do not believe the court should deny Ms. Jacobellis the opportunity to be heard by this court.
All right, so I'm going to take that issue up right now before we start hearing from counsel and witnesses. So I do have some comments to place on the record. First of all, Connecticut General Statute Section 5491C defines victim as a person who is a victim of a crime, the legal representative of such person, or a member of a deceased victim's immediate family. The statutes, however, do not go on to define immediate family for purposes of Section 5491C. Therefore, the statute is not plain and unambiguous, and the court does consider extra textual evidence. The case of Morrow versus Ripley does a good job at summarizing the various terms and application of the word family and immediate family in different statutory sections throughout our case law history. I'll point out that the legislative history doesn't seem to shed light on the issue for purposes of this particular statute. The word family is a word of great flexibility, its meaning varying according to the connection in which it appears. The court in Fisher versus Hodge added that the word family is one of flexible and uncertain meaning and will be construed differently as the circumstances require in order that the meaning in which it is apparently used in any given case may be carried into effect. Family has been defined to mean a group of persons living under one roof, under which the limiting word immediate has no relevance because there exists no degree of membership in that group. On the other hand, family has been used to mean persons of common ancestry, and the word immediate as a limited degree of relationship. However, if blood or relationship is the standard, then a spouse would be excluded as a victim under the statute and unable to provide a statement. The court, in deciding this issue, considers the context of the use of the word, the extent to which the facts of this criminal case, which involve a murder of a young woman, affect not only those related to the deceased, but those persons directly involved in living together with immediate blood relatives of the decedent, and especially in times of adversity, such as the death of a family member, the broader family has tended to come together for mutual sustenance and to maintain or rebuild the family. So in comporting with the expanding sense of family in today's society, we recognize that often people with no biological relationship in a household unit or family undertake the most important duties and take on strong emotional relationships with non-biologically related members. Our Constitution of the state of Connecticut provides victims' rights. In liberally construing those rights, this court is construing the statutory term of immediate family in this case to include the persons who, in the court's opinion, are family members and who have maintained a close family-like relationship with the decedent, blood-related or not, and who have been greatly affected by the defendant's conduct. So I will go ahead and let Jody Jacobellis' statement stand in the PSI, and I will allow Ms. Jacobellis to make a statement here in court today if she so chooses to do so. And Attorney Gavin, there were additional statements, one additional statement perhaps by another in-law and a maternal aunt. The court is going to apply that definition to those two members as well relative to incorporating immediate family to allow those statements to stand in the PSI.
Thank you, Your Honor.
All right, and then lastly, Attorney Stein, Attorney Gavin did raise the issue of the limitation in the statute relative to victim statements and that the statements must concern the facts of this particular case. Obviously, the benefit of all persons here who are intending to provide a statement to this court, and Attorney Stein, I'll hear from you as well. This case obviously involved the murder of Christine Holloway. These did not concern the disappearance of Vanessa Morales. So I would ask that witnesses appropriately tailor their statements to the court in relation to the terms and confines of the statute. Attorney Stein, do you wish to be heard on that matter?
Only just to briefly indicate, as the court has previously ruled, that there is an intertwining nature between the facts, and as the court has previously ruled with regard to the disappearance of Vanessa Morales at the time of her mother's homicide.
And the court's ruling, just so the court can make a clear record, was relative to the evidence as it was coming in and the fact that the investigation was intertwining. So in keeping with allowing relevant evidence to come forth before the jury concerning the adequacy of the police investigation, as well as allowing the state to move forward with evidence on the police intent on the murder, the case did allow some mention of the fact of the child being missing. However, there's been no determination relative to any conduct on behalf of Mr. Morales as it is connected to the child to Vanessa Morales. So I hope everyone comports with the court's statements in the confines of our statutes for providing those statements. Everyone today has respected the process, and I hope we continue to do so. All right, at this point in time, I am going to turn to Attorney Stein now that we've dealt with the PSI report. Attorney Stein, I will take your comments first, and then if there are any family members or representatives of the victim who wish to be heard or any other 5491C materials, I'll ask for those to be presented to the court.
Thank you, Your Honor. Court, please. On April 22nd of 2025, the defendant, in this case Jose Morales, was found guilty for the murder of Christine Holloway and the subsequent tampering with physical evidence related to the crime of murder by a jury of 12 citizens of this judicial district and beyond all reasonable doubt. The crime was brutal. This crime was a case of domestic violence at its worst. At least 8 separate and distinct blows to her head with an instrument that left distinct 1-inch circular bruises and indentations and fractures in the skull of Christine Holloway, fractures so severe that a lobe of Christine Holloway's brain was completely avulsed from her head through the gaping hole in the side of her skull. Fractures so severe that a forensic anthropologist was unable to completely rebuild the skull during the post-mortem examination. Numerous other traumatic injuries and fractures to her face, chest, and back. Only two things could possibly make this fact pattern worse. First, over the next 36 or so hours, the defendant began a methodical and calculated cleanup of this unimaginable scene. By his own remorseless words, he described covering her head with a cloth so he would not have to look at her each time he stepped over her, not to summon help, but to go out and buy cigarettes or a blunt, or to go on his run to the education bins, or the various other drives he took over those nearly 36 hours. He coldly described soaking up Christine Holloway's blood with towels, wiping away the blood splatter, sorting through the blood-stained clothes and toys that he was bagging and staging on the front deck, picking up pieces of her skull and disposing of them in the kitchen sink garbage disposal, disrobing her body, dragging it to a bathtub, stopping to take a nap, while members of the Holloway family and the Ansonia Police Department frantically searched for Christine. And then ultimately calmly leaving the scene, only to have a short neighborly chat with George O'Mara. Shortly after, the Ansonia Police Department conducted a welfare check at the home looking for Christine. The second aggravating factor of this horrible crime pertains to the disappearance of Vanessa Morales. Now, I am well aware that this trial is not about Vanessa Morales, nor has the defendant been convicted of any crime as to Vanessa Morales. But as this court found when ruling on pretrial motions, the police investigation pertaining to her disappearance was exceedingly intertwined into the police investigation and into the nature and circumstances of Christine Holloway's death. And I believe it is something that the court may consider in its broad discretion when fashioning a sentence within the statutory limits for which the defendant has been convicted.
Well, I'm going to object. This is exactly what the court just ruled on. Exactly.
Attorney Gavin, I appreciate your objection and the presentation on the record when the court enters its decision as to whether or not the court.
Thank you.
By all direct and circumstantial evidence presented in this case, together with the reasonable inferences that need to be developed from the evidence, 14-month-old Vanessa Morales was last seen in the presence of the defendant and her mother in the early morning hours of December 2nd, 2019.
Your Honor, this is so far afield from what the court just ordered here. This is attempting to influence this court inappropriately in regard to a matter that is not before the court. And you've instructed the state not to do that, as well as the other witnesses.
Attorney Stein, I'm going to bring you back to the court's instruction relative to the interplay. That was with respect to the investigation. I will just note for the record that the court is here to sentence the defendant on the charge of murder and the charge of tampering with evidence. This court will not be taking into consideration the fact that missing child Vanessa is in any way, shape, or form related to any conduct with respect to the defendant. The defendant is not charged relative to Vanessa Morales, and the state's charges and the jury's verdict are not based on any relation to Vanessa Morales.
I understand, Your Honor.
Strictly instructed, and counsel was strictly instructed, and the court had ruled on that. So with respect to sentencing, please move forward with relative to any facts concerning this particular verdict.
I understand, Your Honor, but I believe that the court consider all aggravating as well as mitigating factors with regard to the intertwined nature of these facts. But I will move on. In a moment, Your Honor is going to hear from members of the family of Christine Holloway. They will describe for you not only the pain, loss, and anger that they felt when this crime occurred over 5.5 years ago. They will describe for you their continued pain and anguish that they have endured throughout this entire process. In addition to having to sit and live through a trial on the merits of this case, the family endured a 3-month police investigation that was necessary to secure an arrest warrant before the defendant was ultimately arrested and arraigned in February of 2020. However, before anything of substance could occur, COVID threw our legal system as well as our world into complete disarray. By the time the world restarted and this case began moving forward, Mr. Morales changed lawyers. It took time for Mr. Morales to secure Attorney Gavin, and then time for Attorney Gavin to come up to speed in a case of this magnitude. The process has been painfully slow to a family demanding answers and justice. They had to endure listening to the defendant deliver a self-serving, nonsensical story, not supported by any other reliable or credible evidence. And now the process is almost over, and Your Honor will soon sentence Mr. Morales. I know no matter what the sentence this court imposes, it will feel empty and hollow to the Holloway family because they still do not have answers. The only person with the answers is Jose Morales. It is unfortunate that the only answers that Mr. Morales provided during the pendency of this entire case were designed to deflect his personal responsibility for this unspeakable crime, and were so unbelievable that a 12-person jury of his peers convicted him of the crime of murder and tampering with physical evidence in only 2.5 hours of deliberation following a nearly 2-week trial. This matter is still very raw to them, and with the court's permission and with the assistance of Ms. Fountain, the victim's advocate, I would like to present them to you now. I'll start first with Anna Radinsky.
I am going to start asking you to name on the record.
My name is Anna Radonsky. Good morning, Your Honor. Thank you for the opportunity to address the court. Can everybody hear me? Our family would like to thank the jury, Attorney Stein, Attorney Durso, Inspector Winkler, Inspector Hyatt, the entire state attorney's office, Ansonia Police Department, members of the FBI, and both victims' advocates for Mika Fountain and Jenny Abuto, and all who took the stand in this trial. I will never know how the vicarious trauma impacted all of you, but we will be forever grateful. My name is Anna Radonsky, and I am the youngest of 6 children. Christine Holloway is my first niece. I called her Chrissy. Debbie, Chrissy's mother, is my oldest sister. My other sister, Kathy, died at 34 years old of lymphoma, and that was the worst day of my life. I didn't think I would experience another worst day like that. However, my beautiful, brilliant, kind, caring, spiritual niece was brutally murdered on 12/2/2019. How does one even begin to start to tell how this has affected my life as well as our family and friends? I would like to start with some background about Chrissy. She was the first person in our family, in her family, to obtain a bachelor's degree. She and I shared a bond with our faith. I chose Christina as my confirmation name because I loved her so much. She loved children, she loved her job, and taking care of so many adorable children at the daycare where she was employed. She was passionate and full of love. I moved to Nashville in October 2019 for a new job, and Chrissy and I would FaceTime with Vanessa during bath time or dinner. We supported each other's passions. She would open the freezer door while Vanessa was playing with her toys, and as soon as Vanessa heard the freezer door opening, she knew it was frozen mango time, and she would crawl as fast as she could, giggling all the way. I hope wherever she is now, she is still enjoying her frozen mangoes. On 12/2/2019, Chrissy was taken away from us, and Vanessa has yet to be found. My sister, Debbie, was left devastated and in shock. They say the worst pain is a mother losing their child. I watched my mom suffer through the loss of my sister, 34 years old, and now I watch my other sisters suffer through that same loss without Chrissy, and then some, with Vanessa still missing. Not to mention that 8 months after Chrissy was murdered, on August 7th, 2020, my oldest nephew, Chrissy's brother, John Holloway, lost his battle with gastric cancer, leaving his daughter behind for us to raise. Again, my sister lost another child, and Vanessa is still missing. I moved my mom from Connecticut to Nashville with me to get her away from all of the news and media in Connecticut because it was just too much for her. Chrissy was her first grandchild, and her great-granddaughter is missing. I listened to her cry, and we would hold each other as tight as we could, and the tears would continue and continue. There is nothing to say, just tears. She would say, "Anna, why? Why? There is no answer, still no answer." My mom is my best friend, and she passed away in August 2023 at 97 years old. I wanted her to stay here forever, but I'm grateful that she didn't have to witness this trial. I know she is in heaven with her husband and my sister Kathy and Chrissy and John Holloway, and I know that they are taking care of each other. In preparation for Chrissy's funeral, our family tackled it as a team. We each had a job to do, and my task was to go to the Gates of Heaven Cemetery and make the arrangements. As we drove that day, so many thoughts were going through our hearts and souls. Vanessa's still missing. When we arrived at the cemetery, we were welcomed by the staff with opening and caring arms. We had to ask them if there is a way they could dig the hole for Chrissy a little bit deeper in case Vanessa had to join her. Let me repeat that. We had to ask if they could dig the hole a little deeper in case Vanessa would be joining her. Nobody should ever have to think about asking that question. Nobody. How does one go on? I recall packing my suitcase to come home after Chrissy was murdered. I packed warm winter clothes and boots because I thought I would be looking for Vanessa in the cold woods. I packed clothes for a wake and funeral for my 43-year-old niece. It all seemed surreal. I walked through the airport looking for Vanessa. Stephen and I took on the task of cleaning Chrissy's apartment. Once released from the police and detectives, I will never forget when we opened the door and broke down crying in each other's arms. Once again, we had to carry on. As we were cleaning the apartment, we go to the kitchen sink and wash our hands. I noticed water coming out from under the sink. A piece of the pipe was missing and there was no bucket anywhere. I thought this was weird. I thought to myself that perhaps the police took it to see if there was any evidence on it from someone else washing their hands. It was not until the trial that I learned that the pipe was removed with the garbage disposal and my brilliant niece's skull pieces were located. Well, most of the pieces anyway. I have PTSD from the sound of garbage disposals now, and I jump out of my skin. I can't wash a pot after having beets for dinner because the beet juice in the sink reminds me of blood. Stephen and I cleaned and packed up the apartment, taking multiple breaks as we had to hold each other up from sadness, shock, and exhaustion. I thought the missing carpet cutout from the investigation was the only part of Chrissy's nightmare. I was advised by my family and friends not to read anything online because of the graphic nature of the situation. I cleaned the bathroom with Stephen, only to find out during the trial for the first time that Chrissy's body was found in the bathroom and the carpet cutout was just the beginning of her torture. How has this affected me? Emotionally, I have anxiety, depression, and PTSD. I have a psychiatrist and a therapist, and I'm on 3 medications to help me. I have severe insomnia, and I feel like someone is going to walk behind me and kill me every night when I go to sleep. I added an alarm to my apartment. I got a weighted blanket. I adopted a rescue dog from the Humane Society who actually rescued me. I have PTSD from the sound on the phone for the Amber Alerts. I had to remove it from my phone because it was such a trigger for me. I had a friend, Patrick, move in with me to help me feel safe. He couldn't be here today because his flight was yesterday to go home. He too rescued me. I had just started a new job and relocated to Nashville, and I couldn't just pack my bags and run home to my family. Instead, I had to carry on in anger, sadness, and fear for years. I am a cardiology physician assistant, and I am an expert at my job, sir. I am an expert at my job. I had to remove myself from the courtroom to avoid being present for the medical examiner's testimony, as I would know exactly what she was describing, and I didn't want to know more than I already found out. One day during the trial, my sister and I stepped out of the courtroom because of the graphic detail. We were sobbing uncontrollably, and this young man came up to us and said, "I don't know what you're going through, but would you like a hug?" We held him so tight and cried so hard. And then I told him the story. He now has Vanessa's story too, and I thank the Lord for the kindness in his heart. I really think that was Chrissy sending him to us. Every day at court in April, I would look into the eyes of that monster because my only voice was my eyes. Well, now I am not done speaking. I have since moved back to Connecticut, and I spend my time making colored copies of Vanessa's missing child photo and hand them to people and hang them everywhere I go. I've gone to pediatricians' offices, parks, libraries, and beaches distributing them. When I am out to dinner, I always sign the receipt for Pray for Christine Holloway and Please Find Vanessa. Your Honor, how this murder has affected our family and friends cannot be described. What was done to my niece, Christine Holloway, is unforgivable and disgusting, and that monster continues to lie. Where is Vanessa? How could someone be so cruel? I hope that he stays in prison forever, forever and ever, so he can't hurt anyone else ever again. I hope every day in prison is hurtful for him and awful in every way imaginable. We will never stop searching for Vanessa and sharing our story. We ask that everyone continues to pray for us. The last thing that I want to read is this note that I found in Chrissy's apartment. This is her writing. This is her writing, her letter. And she says to all first-time moms, "As I sit here and watch my 9-month-old daughter feed herself, I look back on our journey. She is slowly becoming more independent already. She feeds herself, holds her cup, and tries to walk. Each of her firsts are my last, as I do not think I can have another baby. I was high risk because of my age. Bittersweet, but all worth it." The author, Christine Holloway. I also found a little card that I had sent Chrissy in the mail. And it says, "Thanks for all of the FaceTimes with my baby girl. I love them, and you have no idea how much it touches my heart. I love you, Chrissy." I can no longer write cards to my niece, but I know that Christine Holloway is here in this courtroom today, and I thank God for his strength. Thank you.
The next letter being presented is by Deputy Stephen Holloway will be providing that letter.
Honor, this is Stephen Holloway. He's being joined by his fiancee, Jody Jacobellis. My understanding is he is going to be reading the letter on behalf of his mother first, and then I believe Mr. Holloway is going to make his own comments to the court. I'm sorry, Miss Jacobellis is going to go after, and then Stephen.
Me, her, me.
You, her.
Me, her, me.
Okay. Stephen on behalf of his mother, Ms. Jacobellis on behalf of herself, and then Mr. Holloway will end with his own comments.
Thank you very much. Stephen, you may proceed.
Good morning, Your Honor. This is my mother, Christine's mother. I'm just going to read word for word what she wrote. Thank you, Your Honor, for listening to me about this case. My name is Deborah Holloway. I am the mother of Christine Holloway and the grandmother of Vanessa Morales. My life changed on December 2nd, 2019. My oldest child was murdered. My granddaughter was missing. Christine was my oldest child. She was born 10 weeks early, weighing only 3 pounds and 6 ounces. She spent 5 weeks in the NICU, and then I brought her home. As she grew older, she was a role model for her brothers and sisters. She had honors all through school. She was the first in our family to graduate from college. She loved caring for children. She became a teacher in a daycare. Christine loved working with children and always wanted one of her own. When she had Vanessa, I could tell it was the happiest day in her life. It was great to see her so happy. When Christine was ready to go back to work, she took Vanessa with her to daycare center. They were always together and happy. My last happy time I remember was November 28th, 2019. It was the last time we were all together as a family. Then it happened. It was December 2nd, 2019. My life changed completely. I couldn't believe my daughter was dead and my granddaughter was missing. I had to stop going to work and just try to go on to accept what happened. I had many sleepless nights, nightmares, weight gain, anxiety, stressful days, and depression. Some of these I still have today. I've had counseling at work, and also on my own. I watched many nights when my mother would sleep holding Vanessa's clothes in bed with her. I have a granddaughter who's 5 years old at the time. Her name is Serena. She was getting counseling in school. She also got counseling through Child Guidance Center for years now. She is now 10 years old and still wants to know where her cousin is. At Christine's wake, about 200 people attended. Some of them were family. Most of them were parents of children she cared for while she worked for over 20 years as a daycare teacher. They were all grateful for having Christine as their child's teacher. I am still experiencing some symptoms mentioned above. I continue going to counseling when needed. It's been a very long 5.5 years, over 60 court appearances and many days being out of work. I ask that the maximum sentence be given. I have already received the maximum sentence by not knowing where Vanessa is. Thank you, Deborah Holloway.
Good morning, Your Honor. Okay. My name is Jody Jacobellis. I am the fiance of Stephen Holloway and the sister-in-law of Christine Holloway. Excuse me, sorry. I'm here today to share my feeling on how this whole ordeal has not only caused me heartache, but also caused heartache for the entire family. Not only did my family lose a daughter, a sister, and an aunt, but I also lost my best friend. You all may know her as Christine, but I will forever know her as Chrissy. Chrissy was the brightest and happiest person I've ever known. She had a bachelor's degree in psychology and was the best daycare teacher to all the children that were in her classroom over the years. Chrissy was a devoted Catholic and went to church every Sunday with her grandmother. Once Chrissy started dating Mr. Morales, we all noticed everything had to be about him. and she stopped going to church because he wanted time with him. For the last 5.5 years, my family and I have come to every single court date, and every court date we have witnessed the defendant come out, smile with his face, and say hi to his family members in the gallery. Every time this would happen, cause more heartache, pain, and anger because we don't have the opportunity anymore to smile, hug, or even talk to Chrissy or Vanessa. On December 2nd, 2019, our whole family's lives changed forever. The panic and fear driving all around over Ansonia, New Haven, trying to find a loved one. Calling all the area hospitals describing your loved one and her daughter because God forbid she was in a car accident and no one knew who they were. When my fiance and I learned the fate of my sister-in-law, we had to go to my mother-in-law and break the news to her. That her oldest daughter was murdered and her 1-year-old daughter was nowhere to be found. No one can imagine our pain and suffering for over the past 5.5 years unless you have lived it yourself. This is a wound we will all have to live with for the rest of our lives. My family and I have missed so many holidays, birthdays, and milestones with Chrissy and Vanessa. No one can give us that time back with them. Now my family and I get to celebrate those holidays and birthdays at Chrissy's gravesite. Every day I think about picking up the phone and calling Chrissy. But then I remember I can't, because she will never pick up her cell phone again. I miss having conversations with my sister-in-law, talking about everything and anything. Every day I have to think to myself how another human being can take another person's life. And then I realize he's not a human being. He's nothing but a monster. A monster that must live for the rest of his life knowing what he did and caused the family. There has been no remorse or empathy coming from this monster. Yet my family and I must have to relive the nightmare every minute of the day when we go out and see a child who may look like Vanessa. All the monster does is think about himself. He is nothing but a selfish, self-centered, narcissistic piece of trash that should live with his life in an 8x8 cell. Deep down in my soul, I know this monster knows exactly where Vanessa is, and he knows exactly what he did to my sister-in-law. The weekend of November 29th of 2019. My family and I will never back down, and I will continue to search for Vanessa. No, I'm sorry. We will continue to search for Vanessa. When I laid my sister-in-law to rest, I made a promise that Vanessa would come home to my mother-in-law. And I will continue to keep Chrissy's memory alive and tell Vanessa all about the wonderful things Chrissy has done in her life and how much she loved and cherished and will forever love Vanessa with her whole heart. I know my sister-in-law was welcome to the gates of heaven, but I pray when your day comes, you may rot in the gates of hell.
Thank you, Ms. Jacobellis.
Good morning, Your Honor. I'm
morning,
Stephen
Mr.
Holloway, Christine's brother.
Good morning. Please take your time.
I'm not sure what to say, so he should definitely die in jail. He should never get out. He shows no remorse. Not one tear has come down his face this whole time. Even if he doesn't remember, which we all know is a lie. Just the thought of what he could have done should have been enough for it. He destroyed our family. We will never get it back. He deserves to die in jail, rot in hell. That's it. Thank you.
All right. Thank you, Mr. Holloway. Attorney Stein, were there any additional statements?
There are no additional family members that are going to address the court this time, Your Honor.
All right. It is my understanding from Madam Victim's Advocate that there were statements provided to the pre-sentence investigative report authored by persons who are not choosing to provide an oral statement here to the court. I just want to place on the record that I do recognize those statements in the pre-sentence investigative report, and we'll read them. Thank you. Attorney Stein, any additional comments?
Just briefly, Your Honor. So with regard to, again, the things for Your Honor to consider, I know Your Honor was attentive to the evidence during the course of this case. You are well aware of the facts of this case. You are as well aware now, having heard from the family for the first time, the extent and the nature that this has torn this family apart during the exceedingly long period of time that it took for this case to come to conclusion for many different reasons. Amongst the other things that the court may consider is contained in the PSI, and I think it is not insignificant. The court should consider the fact that this is not Mr. Morales' first contact with the criminal justice system. He has criminal convictions that are outlined on page 16 and 17 of the pre-sentence investigation. They include narcotics charges, sale of narcotics charges, gun charges, larceny charges, but also, and not insignificant, previous family violence charges, domestic violence charges. This was a domestic violence case. This was violence at its absolute worst. There is nobody who could have possibly sat here and listened to the testimony of the medical examiners and the police officers detailing the nature of the scene that they otherwise had to process, that could believe that anything but a substantial prison sentence is called for Mr. Morales. And that therefore, based upon all of the foregoing, I'm going to ask this court to deliver upon Mr. Morales a lengthy prison sentence, and not just to bring some measure of justice to Christine Holloway and her family, but also to bring some sense of closure to the many other people of the greater Ansonia community and beyond that have become familiar with this case and have been following it some since its very inception. And based upon all the foregoing, I would simply like to thank the court, thank my co-counsel, Attorney Durso, my paralegal specialist, Ms. Meehan, as well as my inspectors, Hyatt and Winkler, as well as the Ansonia Police Department and their state and federal law enforcement partners for everything that was involved in bringing this case to this court.
Thank you, Attorney Stein. Attorney Gavin, at this time, I would take your comments, and then if Mr. Morales wishes to be heard, I'll hear from Mr. Morales.
Thank you, Your Honor.
Thank you.
I'm going to be very brief, Your Honor. I would like to thank the court and your staff who have been nothing but wonderful to us during the course of the proceedings, and that includes everyone. Your Honor, this is a case that's directly and causally related to the use of PCP. The state knows from the past criminal history here that Mr. Morales suffers from a drug problem, came in here, took the stand right there, testified about his use of PCP. So the issue is at this point is what is an appropriate sentence for Mr. Morales at 48 years of age? And that's a difficult call for the court. I do want to just make a suggestion to the court because you were not involved in any of this. We had extensive negotiations to avoid a trial in this case. Mr. Morales offered to plead guilty to murder and accept a sentence of 35 years to avoid the heartache that this family has gone through today. And for a variety of reasons, none of which were related to Your Honor, that didn't come to fruition. But he did accept responsibility and agreed to plead to the charges. So, Your Honor, at 48 years of age, I would suggest to the court that a sentence of 35 years is appropriate. I think we can all do the math here, and I think that given the agreed upon number of 35 years that was not put into fruition, that would essentially be a life sentence. We would anticipate that there would be any release, certainly on the murder charge where you would serve day for day. So, Your Honor, Mr. Morales was kind enough. We've met with him. Peter and I have been with him over 60 times up at the correctional facility. We went through the pre-sentence report, and he asked me, he had written out a statement, and I advised him not to go ahead into the public forum. Obviously, he's under no obligation to do so, but I do want to let you know that was my advice to him. That is contrary to what his intention was. So, Your Honor, it's an extraordinarily difficult case. It shows the ills of PCP and drug use in our society. There's no question about that. We would just ask the court to impose a fair and reasonable sentence. Thank you, Your Honor.
Thank you. Mr. Morales, I'd like to address you for a moment based on the comments made by your counsel. Sir, you do have a right to be heard, a right to allocution here at the sentencing proceeding, although you do not have to present comments to the court. Is it your decision to not present a statement to the court?
Yes, Your Honor.
Okay. All right.
Thank you, Your Honor.
You're welcome. Thank you, Attorney Gavin. Attorney Gavin, are there any additional statements or comments that you'd like to put before the court? In addition to, I did take into the court record the certificates that you provided.
And I appreciate that, Your Honor. He's been incarcerated for over 5 years, really in absence of any disciplinary history. He's doing his best in there, and so we ask the court just to incorporate that into the ultimate determination. Thank you, Your Honor.
Thank you. All right, so at this time, I just want to point out again, the defendant has been convicted of murder and tampering with physical evidence by a 12-person jury. I did hear a plea to the court by defense counsel regarding PCP use. Intoxication was presented to the jury. It could have been relied on in terms of reaching that intent element of murder and tampering with physical evidence, actually. And the jury did move forward with convicting the defendant of murder and tampering with physical evidence. Now, in anticipation of sentencing, the court has reviewed the pre-sentence investigative report, my notes on the evidence, and the verdict. The court did hear the same evidence as the jury, and that evidence supports the verdict. In imposing sentence today, the court does consider a number of things, which the court will take the time to highlight for purposes of our record. The pre-sentence investigation report by probation, in which the officer recommends incarceration only. The court also considered the information contained in the pre-sentence investigative report, looking for mitigation. I will highlight some of the information from that report for the record. The defendant's age, now 48 years old and around 43 at the time of the murder, and tampering with physical evidence. The court has considered the defendant's family background as described in the PSI report, including the makeup of his family, his childhood experiences, and the relationship that he has with his mother, stepfather, and living brother. The defendant reports, and the court will acknowledge perhaps a difficult upbringing in that his father, who was killed when the defendant was 11, although nice to him, was apparently not so nice to the mother and older brother. The defendant reports his childhood overall as good with ups and downs. His mother always has been supportive and loving. They do have a good relationship, and the stepfather has become his psychological father. His mother and father still support the defendant, believing in his innocence, although acknowledging their love for the victim and expressing the amount of suffering all family members are currently going through and have been going through for many years. The court notes that the defendant reports a history of PCP use back to 1993 with sober periods and periods of relapse, and a last reported use in 2019. The PSI also documents intoxication and marijuana use at an early age and the use of illy back in 1994 before completing a 6-month drug program during a prior period of incarceration without patient treatment during a period of parole. The court will also note, however, that the court has no evidence in the trial, aside from the defendant's testimony, of any PCP intoxication at the time of the murder and the tampering of physical evidence in terms of laboratory results. So the evidence was limited to the testimony of Mr. Morales. With respect to medical and mental health of the defendant, the report indicates some childhood mental health therapy, limited treatment for anxiety, post-traumatic stress disorder as an adult, but nothing ongoing and no definitive diagnosis noted from any medical or mental health provider by the writer of the SI report. The court has considered the defendant's work experience and educational background. It does appear from the report that the defendant did hold employment for some period of time prior to being incarcerated, and also that he did complete high school and started college with no degree. Court notes the defendant's prior criminal history, which includes domestic violence with a felony conviction for violation of a protective order in 2012, failure to comply with conditions of probation resulting in 2 violation of probations, and multiple felony drug sale related offenses with convictions dating back to 1996 and into 2000, which led to lengthy incarceration and lengthy periods of special parole. This court has carefully listened to the statements of Christine's Aunt Anna, Jody Jacobellis, Christine's brother's fiance, Christine's best friend, and Stephen Holloway, Christine's brother. I've also listened to the statement read into the record by Mr. Holloway from Christine's mother, and I have read the written statements that were provided to the court by way of the pre-sentence investigative report. I've considered the comments of the state's attorney, defense counsel. I've reviewed the certificates provided by defense counsel concerning the defendant's completion of certain courses and instruction during incarceration. I do want to acknowledge the difficult task it must have been for family members to give a statement to the court. Those statements were extremely emotional. I can't imagine how you feel, but I do recognize what you have been through over the course of many years to get to where we are here today, and the difficult task it must have been relaying how you felt to the court just momentarily. I want to let the record be clear of a few things. This court has not considered any statements or information provided to this court during this sentencing proceeding relative to any correlation between the defendant and missing child Vanessa Morales. The court recognizes its limited role in this particular sentencing proceeding on the guilty findings of murder and tampering with physical evidence. The sentence imposed reflect the court's findings relative to solely those charges. I also want it noted for the record that multiple members here in support of the decedent have come into court today with T-shirts that depict the face of Christine Holloway. That is your right to do so. I did not preclude you from doing so, but I will note from the record that the court was not unduly influenced by that display on your apparel. Sentencing in a case such as this is a monumental task for any judge. The court must consider the goals of sentencing, which include, among other things, the court's obligation to impose a fair and just sentence, which enhances the public safety, holds the offender accountable, affects general deterrence in order to reduce criminal activity and promote rehabilitation. In doing so, the court also considers the seriousness of each offense and the facts established at trial. I'm not going to restate all the testimony and evidence that was presented during the trial of this case, and I do wish to spare the family members of any additional pain. However, I must comment briefly on the evidence that the jury heard for the benefit of any future proceedings. It was established beyond a reasonable doubt, our highest burden of proof, that the defendant specifically intended to kill and did in fact cause the death of Christine Holloway. It was further established beyond a reasonable doubt that the defendant intentionally tampered with physical evidence relating to the homicide of Christine Holloway. The evidence presented to the jury established that Christine was only 43 years old when her life was needlessly and violently taken from her at the hands of the defendant. This was not accidental, as the jury found, but rather intentional. It was a gruesome, intentional physical attack on Christine. The evidence that the jury heard included multiple blunt force injuries to Christine's head and neck, including skull fractures with a minimum of 8 blunt force impacts, leaving behind a horrific crime scene full of blood and brain matter and the lifeless body of a young mother, sister, daughter, co-worker, and friend. In lieu of calling the police or contacting anyone for help, the evidence presented to the jury indicated that the defendant stayed at the apartment, attempted to clean the bloody mess on the floor, discarded brain matter in a sink, and collected and discarded other evidence with blood on them at a donation box. In fact, bags of physical evidence, including children's toys splattered with blood, adult clothing, and other objects, all while leaving the lifeless body of Christine Holloway in a bathtub back at the apartment. Christine's body was left in a bathroom bathtub with candles lit and a skylight open. The defendant fled the scene. The defendant did take the stand in his own defense, telling the jury of drug use and unknown intruders, and how one of those intruders struck Christine multiple times with a crowbar, and one took his daughter and ran out the door. A jury of 12 rejected his account of what happened to Christine, and the jury's findings are supported by the evidence. To the victim's family members and friends, thank you for your patience with this process, which admittedly has been extraordinarily long to bring this case to conclusion, and most certainly very difficult to endure. Although a conviction and sentence cannot bring back your loved one, I hope that it will provide some closure as to the investigation into Christine's death and open a path to the healing process, which I'm sure will be a lifelong process for many, if not all of you. I have heard through your statements and your letters to the court, which have provided a sense of life to Christine here in the courtroom. I understand how you feel today, how you felt for many years, and you've given the court some indication of the type of person that Christine was. The impact of this crime, of the defendant's conduct within our society, is profound. A vicious crime such as this severely impacts the overall feeling and safety in our society. Society should not have to fear such careless indifference to human life. It makes you question who really lives next door to you. Christine had the right to be safe in her relationship with her young daughter's father, safe in her own home. This was a cruel, intentional, senseless, violent act. The defendant must be deterred from ever committing such an act again, and the sentence imposed must reflect the court's intention to deter generally such violent, senseless acts from happening in our society. The facts of this case, along with your criminal history, Mr. Morales, leave this court to believe that you have no regard for the rule of law and a callous disregard for human life. Your record clearly establishes that prison sentences, probation, and special parole do not dissuade you from committing future crime. Any consideration to be given to the aspect of rehabilitation in this case pales in comparison to the severity of these crimes. Mr. Morales, you are a dangerous person, a significant threat to society, and you need to be removed from the community for a substantial period of time. The victim's family, as well as the members of society, expect the guilty to be held accountable for their actions and rely on the criminal justice system for some measure of closure. No sentence or comments by the court will lessen the profound sense of loss caused by your actions. But you, Mr. Morales, will be held accountable and sentenced accordingly. Mr. Morales, please rise.
Stand up.
Upon the court's considerations as outlined on the record, the following sentence is hereby imposed. As to the finding of guilty of the crime of murder of Christine Holloway, it is the sentence of the court that you be committed to the custody of the Commissioner of Corrections for a definite period of 60 years to serve, which in accordance with our statutes is defined as life. As to the finding of the crime of tampering with physical evidence, it is the sentence of the court that you be committed to the custody of the Commissioner of Corrections for a definite period of 5 years to serve, to run consecutive to the sentence on the murder for a total effective sentence of 65 years to serve. At this point in time, I'm going to note your right to appeal. I'm also going to note that Connecticut General Statutes 1898E does not render you eligible for risk reduction credits on the murder, that 60-year sentence imposed. You may be eligible, however, pursuant to our statutes, if applicable, to earn risk reduction credit on the sentence imposed on tampering with physical evidence. Total effective sentence, 65 years. We're going to waive any costs and fees for good cause in view of the lengthy incarceration. You do have a right, sir, to seek sentence review and modification as provided by way of statute as applicable. Madam Clerk will outline the documents she's providing you, which will also include a pardon brochure. Madam Clerk, would you please provide defense counsel and defendant with a copy of the documents, and please state on the record what documents you are providing.
Your Honor, we have executed the documents you're referring to and forwarded those to Madam Clerk for filing after the conclusion of today's hearing.
Okay, so just let the record reflect that the defendant is in receipt of his right to appeal, his conviction, his right to sentence review modification, as well as a pardons eligibility brochure. Counsel, is my understanding that there is property being held in this matter.
With the court's permission, we'd ask that all seized property be held pending the appeal.
As well as the fact, Your Honor, that there is an open investigation, so all property that was currently entered into evidence, ask that it be maintained by the clerk's office for appellate purposes as well as additional investigatory purposes.
All right, the court will order the property be held for appeal purposes. The court wants to thank counsel for your professionalism in delivering your case and presenting your case to the jury during the trial, and your arguments to the court of the sentencing proceeding, as well as your courtesies to one another. And I'd like to also thank the members of our audience for maintaining courtroom decorum during the trial and the sentencing proceeding. I appreciate that. Thank you. At this point in time, if there's nothing else.
There is two additional matters, Your Honor. I'm not sure if I know that there are costs. I'm not sure if the court entered orders with regard to that.
I did. Costs and fees are waived.
With regard to, there is a second file. It has been docketed today at my request. I will identify it as State of Connecticut versus Jose Morales. It is AAN CR 19-022-552T. This is a matter, 2 counts of criminal possession of an electronic defense weapon. This is a matter, it was an arrest effectuated by the New Haven Police Department during the course of the investigation. In this case, it was a matter that was pending in the New Haven Judicial District, and due to the fact that it was expected that this case was going to take a while, I agreed to accept jurisdiction of that case, and at this time, state is entering a nollie to both counts of those information based upon the sentence imposed by this court in the economy and administration of justice.
All right, so relative to that particular case, the court will go ahead and note the nollie. I am assuming due to the nature of the charges, there's a lot of property in that case.
There is property. I would ask that those be destroyed.
No issue with that.
All right, court will go ahead and order the destruction of the property held in the case that was nollied. Is there anything else to be addressed by the court?
Not from us, Your Honor.
All right, thank you.
Thank you.
State?
I'm good, Your Honor. Thank you.
Court stands adjourned. Thank you.